Question 1. A notary public commissioned in New York State wishes to resign their commission prior to its expiration. Which of the following is the correct procedure for resignation? A. The notary public must send a written notice of resignation to the county clerk in the county where their oath of office was filed. B. The notary public must surrender their commission certificate directly to the Department of State. C. The notary public must send a written resignation notice to the Department of State, along with their official stamp. D. The notary public must provide written notice to the Department of State, but the commission is automatically terminated upon cessation of notary acts. Answer: C. The notary public must send a written resignation notice to the Department of State, along with their official stamp. To resign a New York Notary Public Commission before its expiration, the notary public must submit a written notice of resignation directly to the Department of State. It is also required that the official stamp, if one was used, be surrendered at the same time to ensure proper record keeping and prevent its misuse. This procedure ensures a clear and official termination of the commission, maintaining accurate state records of commissioned notaries. Always follow official channels for any changes to your commission status to avoid future complications. Question 2. A New York notary public is asked to notarize a document for their spouse, who is signing as an individual party to the instrument. The notary public is not financially interested in the transaction. Is this notarization permissible? A. Yes, because the notary public is not financially interested in the transaction. B. No, because notarizing for a spouse always creates a conflict of interest. C. Yes, provided the spouse is identified using satisfactory evidence. D. No, because the notary public is a party to the instrument by virtue of the spousal relationship. Answer: A. Yes, because the notary public is not financially interested in the transaction. In New York, a notary public is generally permitted to notarize a document for their spouse, relative, or employer, provided the notary public is not a party to the instrument and has no direct financial or beneficial interest in the transaction. The core concept here is avoiding a direct conflict of interest, which primarily involves being a signatory on the document or benefiting financially from the transaction. Simply being related does not automatically create a disqualifying interest, making proper identification of the signer the key requirement. Always ensure your impartiality before performing a notarial act. Question 3. A New York notary public receives a document for a sworn statement, affidavit, where the signer has already signed the document. What is the notary public's immediate next step? A. Administer the oath or affirmation to the signer regarding the truthfulness of the statement. B. Require the signer to re-sign the document in the notary public's presence. C. Ask the signer to verbally affirm that the signature is theirs. D. Complete the notarial certificate and affix the stamp. Answer: A. Administer the oath or affirmation to the signer regarding the truthfulness of the statement. When performing an acknowledgment or jurat, the notary public must ensure the signer appears in person and the notarial act occurs at the time of the appearance. For a sworn statement, jurat, the critical step is to administer the oath or affirmation, where the signer swears or affirms the truthfulness of the document's contents. Even if the document is pre-signed, the oath or affirmation must be administered in the notary's presence, validating the content. The signer's physical presence and the spoken oath are paramount for a valid jurat, ensuring the signer takes responsibility for the statements made. Question 4. A New York notary public is approached by a former client requesting a certified copy of a document that was notarized by the notary public 2 years ago. The client specifically asks for a notarized copy. How should the notary public respond? A. The notary public should make a copy and then certify it as a true copy, affixing their notarial seal. B. The notary public should refuse, as New York notaries are generally prohibited from certifying copies of documents. C. The notary public may certify a copy only if the original document is a public record from a government agency. D. The notary public may create a copy and then execute an affidavit stating they made the copy and it's accurate, rather than directly certifying it. Answer: B. The notary public should refuse, as New York notaries are generally prohibited from certifying copies of documents. New York notaries public are not authorized to issue certified copies of documents. Unlike some other states, New York law does not grant this power to general notaries public, meaning a notarized copy, in this sense, is not a recognized notarial act. The only exception is for protests of negotiable instruments, where a notary can provide a notarial certificate of protest. Always remember your specific state's limitations. Never perform an act outside your legal authority, even if a client requests it. Question 5. A New York notary public changes their business address within the same county where they originally filed their oath of office. What action, if any, is required? A. The notary public must file a change of address form with the county clerk and the Department of State. B. The notary public must notify the Department of State in writing of the new business address. C. No action is required as long as the notary public remains within the same county. D. The notary public must file a new oath of office with the county clerk for the new address. Answer: B. The notary public must notify the Department of State in writing of the new business address. In New York, if a notary public changes their residence or business address, they are required to notify the Department of State in writing of the new address. This notification is crucial for the Department of State to maintain accurate records and ensure proper communication with commissioned notaries. While changing counties would require an additional step with the new county clerk, simply changing an address within the same county still necessitates informing the Department of State. Always keep your commissioning authority updated on your current contact information. Question 6. A notary public in New York is asked to take the acknowledgment of a blind individual. What steps must the notary public take to ensure the validity of the acknowledgment? A. The notary public must read the entire document aloud to the blind individual before they sign. B. The notary public must obtain a statement from a witness confirming the individual's identity. C. The notary public must be satisfied that the blind individual understands the contents of the document and freely executed it. D. The notary public should refuse the notarization if the individual cannot visually confirm the signature. Answer: C. The notary public must be satisfied that the blind individual understands the contents of the document and freely executed it. When notarizing for a blind individual, the core requirement is to ensure the signer fully understands the document they are signing and is acting voluntarily. The notary public must take reasonable steps to be satisfied of these facts, which may include reading the document aloud if requested, or having a trusted third party read it aloud in the notary's presence. The act of notarization validates the signature and the signer's intent, so understanding and free will are paramount, not just physical sight. Your role is to ensure the signer is aware and willing, regardless of physical challenges. Question 7. A New York notary public is commissioned for a 4-year term. If their commission expires on July 30, 2024, when is the earliest they can apply for reappointment? A. 60 days before the expiration date, which is May 31, 2024. B. 90 days before the expiration date, which is May 1, 2024. C. 30 days before the expiration date, which is June 30, 2024. D. Any time within 6 months of the expiration date, but no later than 30 days prior. Answer: A. 60 days before the expiration date, which is May 31, 2024. New York notaries public may apply for reappointment no earlier than 60 days prior to the expiration of their current commission. This window allows ample time for the Department of State to process the application and issue a new commission without a lapse in the notary's authority. Planning for reappointment within this designated timeframe ensures continuity of service and avoids any interruption to your notarial duties. Mark your calendar for this window to ensure timely renewal. Question 8. A New York notary public is asked to take an acknowledgment for a document written entirely in a foreign language that the notary public cannot read or understand. What is the appropriate action for the notary public? A. the notary public may proceed with the acknowledgment if an interpreter is present. B. The notary public should refuse to notarize, as they cannot verify the document's contents. C. The notary public may proceed if they are satisfied with the signer's identity and the signer confirms understanding. D. The notary public should only notarize if a certified translation of the document is provided. Answer: C. The notary public may proceed if they are satisfied with the signer's identity and the signer confirms understanding. For an acknowledgment in New York, the notary public is confirming the identity of the signer and that the signer voluntarily executed the document. The notary public is not certifying the truthfulness or legality of the document's contents. Therefore, a notary public can properly take an acknowledgment for a document written in a foreign language they don't understand, provided they can communicate with the signer and are satisfied the signer understands the document and freely signed it. Your duty is to the signature and the signer's intent, not the language of the document. Question 9. In New York, which of the following acts is specifically prohibited for a notary public? A. Drawing a will or giving advice on the law. B. Notarizing a document for a close family member. C. Charging a fee higher than the statutory maximum for a protest. D. Administering an oath in a language the notary public does not understand. Answer: A. Drawing a will or giving advice on the law. New York notaries public are strictly prohibited from engaging in the unauthorized practice of law, which includes drawing up legal documents such as wills or contracts, or giving any form of legal advice. These activities fall within the scope of a licensed attorney's practice, and exceeding these boundaries can lead to severe penalties, including revocation of commission. Your role as a notary is to serve as an impartial witness to signatures and administer oaths, not to interpret or draft legal instruments. Question 10. A New York notary public is presented with an affidavit. The signer appears, is identified, and confirms the signature. However, the notary observes that the document has blank spaces and incomplete sections within the body of the text. What is the notary's best course of action? A. Refuse to notarize the document until all blank spaces are filled in by the signer. B. Advise the signer to complete the blank spaces and then proceed with the notarization. C. Notarize the document as is, because the notary's duty is only to the signature. D. Make a note in the notary's record book about the blank spaces, then proceed with the notarization. Answer: A. Refuse to notarize the document until all blank spaces are filled in by the signer. A notary public should not notarize a document that contains blank spaces or incomplete sections that appear intended to be filled in. While the notary's role is not to provide legal advice, notarizing such a document could facilitate fraud or alteration after the notarization, potentially implicating the notary. The best practice is to require the signer to complete all relevant parts of the document before the notarial act, ensuring the document is complete at the time of notarization. Completing the document properly protects both the signer and the notary. Question 11. What is the maximum fee a New York notary public may charge for administering an oath or affirmation and taking an affidavit? A. $1. B. $2. C. $5. D. $10. Answer: B. $2. In New York State, the statutory fee for administering an oath or affirmation and taking an affidavit, Jurat, is $2. This fee is set by law, and notaries public are prohibited from charging more than this prescribed amount for the notarial act itself. While notaries may charge additional reasonable fees for travel or other services, these must be separate from the notarial act fee and agreed upon in advance. Always be aware of the specific fees allowed for each type of notarial act. Question 12. A New York notary public is presented with a document for an acknowledgment. The signer presents a foreign passport as identification, which is current and contains a photograph and signature. Is this acceptable identification in New York? A. Yes, if the notary public can read and understand the passport's details and verify it appears genuine. B. No, only U.S. government-issued identification is acceptable. C. Yes, but only if accompanied by a secondary form of identification, such as a credit card. D. No, because foreign passports are not considered satisfactory evidence under New York law for acknowledgments. Answer: A. Yes, if the notary public can read and understand the passport's details and verify it appears genuine. In New York, satisfactory evidence for identification means the notary public is personally familiar with the signer or relies upon credible identifying documents. A current foreign passport containing a photograph and signature, which the notary public can interpret and verify, is generally considered acceptable. The key is the notary's personal satisfaction that the document adequately identifies the signer and appears legitimate. You must be able to read and understand the identification document presented to ensure it truly identifies the person appearing before you. Question 13. A New York notary public is also an employee of a bank. Their supervisor asks them to notarize the signature of a bank customer on a loan agreement that benefits the bank. Is this permissible for the notary public? A. Yes, because the notary public is acting in their official capacity and does not personally benefit. B. No, because it creates an inherent conflict of interest for an employee to notarize for their employer's customers. C. Yes, provided the notary public receives no additional compensation for the notarization from the bank. D. No, unless the notary public discloses their employment relationship to the signer. Answer: A. Yes, because the notary public is acting in their official capacity and does not personally benefit. In New York, a notary public may notarize documents for their employer or for clients of their employer, provided the notary public does not have a direct personal financial or beneficial interest in the transaction. The bank is the interested party, not the notary public acting as an employee performing a duty. The crucial distinction is whether the notary themselves is a party to the instrument or directly benefiting from the transaction, which is generally not the case when notarizing for an employer's clients. Focus on your direct interest, not your employer's, when determining impartiality. Question 14. A New York notary public's commission is suspended for official misconduct. What must the notary public do with their notary public stamp? A. The notary public must immediately surrender the stamp to the Department of State. B. The notary public must keep the stamp securely locked away until the suspension is lifted. C. The notary public must notify the county clerk of the suspension. D. The notary public must deface or destroy the stamp. Answer: A. The notary public must immediately surrender the stamp to the Department of State. Upon suspension or revocation of a New York Notary Public commission, the notary public is required to immediately surrender their commission certificate and any official stamp used to the Department of State. This ensures that the individual cannot perform notarial acts while their commission is inactive and prevents misuse of the official stamp. Compliance with this directive is critical to avoid further penalties. Always comply with official directives concerning your commission status. Question 15. A person asks a New York notary public to take an affidavit, but insists on signing the document using an X mark because they have difficulty writing. What must the notary public ensure for this to be a valid notarization? A. The notary public must personally witness the X mark being made and have a disinterested witness attest to it. B. The notary public must refuse, as an X mark is not a legally acceptable signature in New York. C. The notary public may accept the X mark if the person also provides a thumbprint. D. The notary public must ensure the individual is mentally competent and intends the X to be their signature. Answer: A. The notary public must personally witness the X mark being made and have a disinterested witness attest to it. When a signer uses an X mark due to an inability to write their name, the New York notary public must personally witness the making of the mark. Furthermore, the X mark must be attested to by at least one disinterested witness who signs their name as a witness to the mark, often right next to the X. This procedure provides additional assurance of the signer's identity and intent when a conventional signature cannot be obtained. Always ensure proper witness procedures for mark signatures to validate the act. Question 16. A New York Notary Public is asked to notarize an affidavit that is dated for a future date. The signer is present and ready to sign today. What is the Notary Public's proper action? A. Proceed with the notarization, but date the notarial certificate with the future date indicated on the document. B. Refuse to notarize the document until the future date arrives. C. Notarize the document today, but ensure the notarial certificate reflects the actual date of notarization. D. Advise the signer to change the document's date to today's date before proceeding. Answer: C. Notarize the document today, but ensure the notarial certificate reflects the actual date of notarization. A notary public certificate must always reflect the actual date the notarial act was performed. It is permissible to notarize a document that has a future date on its content, as long as the notary public correctly dates their notarial certificate with the current day of the notarization. The notary's role is to verify the signature and administer the oath or acknowledgment on the day the act occurs, regardless of the document's internal dating. Always use the actual date of notarization in your certificate, as it records when the notarial act took place. Question 17. Which of the following statements about a New York Notary Public's official stamp is true? A. A notary public is required by New York law to use an official stamp or seal. B. The stamp or seal, if used, must contain the notary's commission expiration date. C. If used, the stamp or seal must contain the notary's name, the words Notary Public for the State of New York, and the county of appointment. D. The use of an embosser is sufficient as an official seal without any additional stamp. Answer: C. If used, the stamp or seal must contain the notary's name, the words Notary Public for the State of New York, and the county of appointment. While New York law does not require a notary public to use an official stamp or seal, if one is used, it must contain specific information, the notary's name, the words Notary Public for the State of New York, and the name of the county in which the notary is appointed. The expiration date of the commission is not a required element on the stamp itself. This information on the stamp helps identify the notary and their jurisdiction, facilitating verification of their authority. Question 18. A New York Notary Public is presented with a document signed by a principal and containing a notarial certificate that is already pre-filled, including the notary's name and commission details. The signer is present and verified. What should the Notary Public do? A. Complete the notarial act as usual, assuming the pre-filled information is correct. B. Refuse to notarize the document, as pre-filled notarial certificates are not permitted. C. Strike out the pre-filled notarial certificate and complete a new one with correct information. D. Check the pre-filled information, and if accurate, simply add their signature and stamp. Answer: C. Strike out the pre-filled notarial certificate and complete a new one with correct information. A notary public should never rely on a pre-filled notarial certificate. The certificate attests to the notary's specific actions and must be completed by the notary at the time of the notarial act. If a document includes a pre-filled certificate, the notary should line through it neatly, ensuring it remains legible, and then complete a new, correct notarial certificate below or on an attached loose certificate. This ensures the certificate accurately reflects the notary's actions and details, preventing potential fraud or errors. Always complete the certificate yourself to ensure accuracy. Question 19. A New York Notary Public is licensed to practice law. They are asked by a client to draft a simple power of attorney and then notarize the client's signature on it. Is this permissible? A. No, because a notary public is prohibited from drafting legal documents, regardless of other licenses. B. Yes, if the notary public charges a separate fee for the drafting and the notarization. C. Yes, because a licensed attorney may perform legal services and also notarize documents. D. No, because this situation presents an unresolvable conflict of interest for the notary public. Answer: C. yes, because a licensed attorney may perform legal services and also notarize documents. While a general notary public is prohibited from the unauthorized practice of law, a New York notary public who is also a licensed attorney is permitted to draft legal documents and then notarize the signatures on those documents for their clients. The attorney is acting within the scope of their legal practice, and their notary commission allows them to complete the notarial act. The key distinction here is the notary's additional qualification as a licensed attorney, which exempts them from the unauthorized practice of law restriction. Question 20. A New York notary public receives a document requiring a jurat, but the signer requests to affirm rather than swear due to religious beliefs. What is the notary public's responsibility? A. The notary public must refuse, as a jurat always requires a sworn oath. B. The notary public must explain that an affirmation has no legal standing in New York. C. The notary public must administer the affirmation, as it has the same legal effect as an oath. D. The notary public should suggest the signer consult an attorney regarding their options. Answer: C. The notary public must administer the affirmation, as it has the same legal effect as an oath. An affirmation is a solemn declaration that a statement is true, made by individuals who object to taking an oath on religious or moral grounds. In New York, an affirmation has the same legal force and effect as an oath. Therefore, a notary public must administer an affirmation if the signer prefers it over an oath, as both are legally valid methods of attesting to the truthfulness of a statement. Always respect the signer's preference for an oath or affirmation, as both fulfill the legal requirement. Question 21. A New York notary public is asked to notarize an affidavit. After identifying the signer, the notary administers the oath. Before the signer affixes their signature, the notary public steps away briefly to retrieve their stamp. Is this procedure permissible? A. Yes, as long as the notary public returns to witness the signature. B. No, the signer's signature must be affixed in the continuous presence of the notary public after the oath. C. Yes, provided the signer does not leave the notary's sight. D. No, because the notary public must witness the entire signing and oath process without interruption. Answer: B. No, the signer's signature must be affixed in the continuous presence of the notary public after the oath. For a jurat affidavit, the notary public must administer the oath or affirmation, and the signer must affix their signature in the notary public's immediate and continuous presence. The entire notarial act, from identification through signature and completion of the certificate, must occur without interruption in the notary's direct observation. Temporarily stepping away breaks this continuous presence and could invalidate the notarial act, potentially allowing for document tampering. Always maintain continuous observation throughout the entire notarial process. Question 22. A New York notary public receives a mailing address change notice from the Department of State. What is the notary public's obligation? A. The notary public is not required to take any action if their physical address hasn't changed. B. The notary public must immediately update their personal records, but no notification to the department is needed for a mailing address change. C. The notary public must promptly notify the Department of State in writing of any change to their residence or business mailing address. D. The notary public must submit a new oath of office to the county clerk reflecting the new mailing address. Answer: C. The notary public must promptly notify the Department of State in writing of any change to their residence or business mailing address. New York notaries public are required to notify the Department of State in writing of any change in their residence or business mailing address. This requirement ensures that the Department of State can maintain accurate records and communicate effectively with commissioned notaries. Failing to update your address can lead to missed communications, including reappointment notices, potentially jeopardizing your commission. Always keep your contact information current with the Department of State. Question 23. A New York notary public is approached by an individual claiming to be a credible witness, to identify a signer who lacks proper identification. The credible witness is a neighbor who does not know the signer personally but knows the signer's family. Can this neighbor serve as a credible witness for identification purposes? A. Yes, because a neighbor is generally considered trustworthy. B. No, a credible witness must personally know the signer and be unrelated to the transaction. C. Yes, if the notary public is personally familiar with the neighbor. D. No, New York state law does not permit identification by credible witness. Answer: B. No, a credible witness must personally know the signer and be unrelated to the transaction. In New York, while the term credible witness is not explicitly defined in the statute, the common law understanding and best practice for notaries public is that a credible witness must personally know the signer and be unbiased, meaning they have no financial or beneficial interest in the transaction. Knowing the signer's family, but not the signer personally, does not establish the required personal knowledge for identification. Always ensure a credible witness has direct personal knowledge of the signer's identity and is impartial. Question 24. A notary public in New York is presented with an instrument for notarization where the notarial certificate includes the phrase, "Acknowledged before me this day of ______20, by signer's name." But the county and state are missing from the venue section. What is the notary's appropriate action? A. Complete the venue section by writing in the county and state where the notarization occurred. B. Refuse to notarize the document until the venue information is added by the preparer. C. Notarize the document as is, assuming the venue can be inferred from the notary's stamp. D. Cross out the incomplete certificate and attach a loose certificate with complete venue information. Answer: A. Complete the venue section by writing in the county and state where the notarization occurred. The venue, county and state where the notarization takes place, is a mandatory element of a New York notarial certificate. If it's missing or incomplete, the notary public must fill it in. The venue establishes the geographical location where the notarial act was performed, confirming the notary's jurisdiction. It's the notary's responsibility to ensure the certificate is fully and accurately completed at the time of the notarization. Always double-check and complete all required fields on the notarial certificate to ensure its validity. Question 25. A New York notary public moves their residence from New York County to Bronx County. What specific filing requirement applies to this change? A. The notary public must notify the Department of State and refile their oath of office with the Bronx County Clerk. B. The notary public must notify the Department of State only. No action is required with the county clerk. C. The notary public must file a copy of their commission with the Bronx County Clerk. D. The notary public must file a new application for a notary public commission in Bronx County. Answer: A. The notary public must notify the Department of State and refile their oath of office with the Bronx County Clerk. When a New York notary public changes their residence to a different county from where their original oath of office was filed, they must notify the Department of State of the address change. Additionally, to exercise their powers in the new county, they must file a certificate of official character or a copy of their appointment, along with a new oath of office, with the county clerk of the new county. This ensures their authority is recognized and recorded in the new county of residence. Always remember to update both the Department of State and the relevant county clerk when moving to a new county.